So many people have heard of the implied consent law, but few truly know what the statute means. So I wanted to take a few brief moments to explain what the statute means, what your rights are, and what your obligations are. So every driver, by virtue of traveling on Pennsylvania roads, has implicitly agreed to comply with chemical testing if an officer has reasonable grounds to believe that the driver is operating the vehicle under the influence of alcohol or some other substance. Now, reasonable grounds will be considered under a totality of the circumstances standard, meaning whether a person in the officer's position would have believed, given all the facts and circumstances available at the time, that the driver could be operating the vehicle under the influence of alcohol or another substance. Now, if the officer has those reasonable grounds, then the driver is required to comply with chemical testing, and if they don't, their driving privileges can be suspended for a period of 1 year or more. Now, those chemical tests include blood tests and breath tests, and the specific test will be chosen by the officer. Notably, however, it does not include preliminary breath tests, meaning the test administered on the roadside, or field sobriety tests. A driver is under no obligation to comply with those testings, and refusal to submit to those tests will not result in revocation of the driver's driving privileges. Additionally, the officer must supply the driver with what's called an O'Connell warning, meaning the officer must inform the driver that refusal to submit to the chemical tests will result in revocation of their driving privileges, and they must also inform the driver that their Miranda rights do not apply to these chemical tests. So if you've been charged with DUI and you're facing revocation of your driver's license as a result of the implied consent statute, I invite you to schedule a free consult with me so that we can discuss the specific circumstances in your case.